The top 5 myths about employer mandates and Title VII. In this post, we are looking at the top 5 myths that we encounter on a day-to-day basis when it comes to employer mandates and Title VII. There is a lot of misinformation put out there in the internet or by word of mouth even from the employer to generally keep the employees confused, fearful, and in the dark when it comes to what rights they have under the law. We are willing to guess that you have heard of at least one of these myths. Hello everyone, my name is Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC, and today we are looking at whether at-will employment, government contracts, on-site service, and part-time work prohibit or prevent an employee from asserting their rights under Title VII of the Civil Rights Act of 1964. Remember that this post, along with all of our other posts, should never be taken as legal advice. You will always want to consult a trusted attorney with your legal questions. Let's look at myth number 1. Myth number 1 is at-will employment. The question goes something like this. I thought, generally speaking, that Michigan is an at-will employment state and that the employer can fire me for any reason. Well, generally and under Michigan law, by presumption, employment relationships are terminable at will by either party, the employer or the employee. However, the presumption of employment at will can be rebutted so that contractual obligations and limitations will be present in an employment situation. One type of limitation is that an employer cannot fire an employee at will for discriminatory purposes. Title VII of the Civil Rights Act prevent employers from terminating employees on the grounds of race, color, religion, sex, and national origin. If an employee has a sincerely held religious belief and the employer is put on notice of that sincerely held religious belief, it doesn't matter that the employee is at will. The employer cannot simply fire them because they have claimed they are religious. Myth number 2, government contracts. The question goes something like this. An employee works for Acme Incorporated. That company conducts business with the government through contracts. Surely that employee has to follow Acme Incorporated's policies when it comes to receiving medications, medical procedures, and mandates, right? Well, generally no, and here's why. If an employee is filing for an accommodation under Title VII based on a sincerely held religious belief, it should not matter who Acme Incorporated conducts business with. Any company like Acme who has been telling their employees, we contract with the government, you have no choice. Let me tell you folks, they've been lying to you. Under Title VII, those who hold a sincerely held religious belief are entitled to assert their rights under the law. Title VII does not state that an employee's rights are void just because their employer has contracts with the government. That is completely absurd, and in fact, it's arguably that an employee who works for a company that could be viewed as a quasi-governmental entity have greater protection under the Constitution, specifically the First Amendment, than just an employee who works for a private entity who does not have any government contracts. That is another topic for another day, and if you would like to see something like that, make sure that you subscribe to our blog on our website by putting your email in there and clicking the submit button. That way you don't miss any posts. Myth number 3, part-time positions. The question goes something like this. I work for a company and I'm a part-time worker. Can I still assert my rights under Title VII and request a religious accommodation? The answer is yes. Title VII does not distinguish between part-time and full-time employment. A part-time employee still have the ability to assert their rights under the law just like a full-time employee would. Myth number 4, public service or a public servant. The question goes something like this. Can I ask for a religious accommodation under Title VII if I work for the local police department, the sheriff's office, the fire department, What about the court clerk, the county clerk? I'm the mayor's assistant. I'm the mayor's secretary. Can I still assert my rights under Title VII? The answer is yes. Just because you work in the public sector does not mean that your rights are void under the law. Arguably, someone who works in the public sector has the ability to assert rights that an employee in the private sector does not. The First Amendment of the Constitution. Myth number 5, on-site workers. The question goes something like this. I have to be on site. I have to interact with customers or patients or clients. Can I still assert my rights under Title VII? The answer is yes. Title VII does not distinguish between an employee who has to be on their company's property versus an employee that can work remotely from home. Under Title VII, if you hold a sincerely held religious belief, you are entitled to assert your rights under the law. It doesn't matter if you have to work on company property or you're able to work remotely. Your rights are still valid and you can assert them under the law. If you would like to retain Radzwion Law PLLC as your trusted attorney, please do not hesitate to contact us. We are here to protect you when you need it most, and we will fight for your freedoms. Thanks for watching. Check out more information and articles, posts, videos on our website, radzwionlaw.com. Subscribe, comment, hit the bell notification, all that stuff that I don't like to say. Thanks again.